Our government is of the people, by the people, and for the people. As we've discussed throughout constitutional law, voting is arguably the most fundamental right in the United States Constitution. It serves as a crucial mechanism that protects people's voice in our democracy. In Shelby County v. Holder, Justice Ginsburg used a memorable analogy in her dissent. Throwing out the preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. Let's extend this analogy to illustrate the contrast between nationalist and federalist interpretations of Congress's power. Both the majority and the dissent agreed that the Voting Rights Act was a success. Section 4 of the 1965 Act included a coverage formula that identified states requiring additional scrutiny and preclearance for any changes to their voting laws. This approach worked effectively. Voting systems were better protected from the storms of racism, such as literacy and knowledge tests, good moral character requirements, and voucher requirements. In Ginsburg's analogy, the umbrella stopped us from getting wet. In 2013, the majority of the Supreme Court adopted a federalist approach, asserting that the coverage formula unfairly impacted the sovereignty of the 9 included states. They argued that the current burden on those states could only be justified by current needs, not by a historic, albeit bipartisan, formula. As the voting systems appeared less discriminatory, the court concluded it may be sunny, so we need to throw away the protection of our umbrella. Ginsburg's nationalist interpretation prioritized the protection of the voters. In our analogy, a nationalist would consider it a broad but reasonable power to simply keep the umbrella at hand, always prepared for future storms. Since 2013, new storms of discrimination have appeared in forms of voter ID laws and gerrymandering. Without our umbrella protection of sections 4B and 5, voters can be left in the cold. But there is hope of sunshine ahead. The Supreme Court favored minority voter rights in the gerrymandering case of Allen v. Milligan, and the John R. Lewis Voting Rights Advancement Act, if passed, could provide a modern measure for the scrutiny of preclearance, thereby reinstating sections 4B and 5.